This is the matter of State of Michigan versus Dustin Proctor, file 25-6865-FH-3. This is set for I believe we have both sentencing and a bond violation. Is that correct? Or is it just the bond violation today?
I think my understanding was it was both, but I think the bond violation is going to be affects sentencing. So
Correct. So I just want to make sure I was on both of them. So, all right. Let me do this.
And Judge, before we did begin, there was something I wanted to bring to the court's attention.
Go ahead.
It was brought to my attention earlier this week, and even today, via a sanction report that was filed by Mr. Hanlon, that Mr. Proctor has been driving a red Chevy Impala without a driver's license. I see him on Zoom right now. I would ask that the court inquire of his location in that car, because I believe he may be driving or in the driver's seat.
Mr. Proctor, where are you at?
I am in the driver's seat, but I'm in my coworker's car at work. So I literally start work as soon as we get off the Zoom.
Say that again. I misunderstood what you
Sorry.
said. You're in what car?
I'm in my coworker's car because I start work as soon as we get off. I was supposed to be at work. I told him I'd start late.
Could you get out of the car and simply show me a picture of the outside of the car, please?
It's red. It's red Impala. My coworker drives a red Impala. He's right on that. Oh, shit. Sorry. What am I doing? How am I turning this around? Here.
And Judge, I believe that license plate will be EYP 6699.
Could you show me what the license plate is, please?
Yep. It's not my car.
Look.
I don't have a car. I wish.
Judge, Ms. Payne, Pamela Payne with District Court today provided photographs to Mr. Hamlin of Mr. Proctor actually getting into that vehicle at the courthouse by himself and driving away. And I do have to inform the court that on Monday, I personally observed Mr. Proctor getting into that same vehicle in the courthouse parking lot and driving it away.
All right. Well, here's what we're going to do. I know that you have a witness here regarding a violation, an alleged violation for a drug, positive drug test. Let's take the testimony as to that one, and then that witness can be excused. And I'm sure she has lots of other things to be doing today.
Sure.
And then we'll address any other pending or potential violations of probation, or excuse me, of bond as to that. So, Mr. Proctor, the allegation right now that we're going to address is that on September the 4th, excuse me, let me find it. On July 24th, 2025, there was a positive test for methamphetamine at Great Lakes Screening and Services. The sample was sent to Redwood Toxicology on or about the above date for confirmation. Redwood Toxicology returned with the confirmed positive test results on August the 7th. And that would be a violation of the drug court bond conditions dated May 15th of 2025. That is the allegation made against you. The prosecution's burden is to prove that by a preponderance of the evidence. You would have the right to remain silent. You'd have the right to have an attorney represent you. You'd have the right to present witnesses or evidence and get an order from the court called a subpoena to require witnesses to appear and testify. You could testify, or you could choose to remain silent, and that silence could not be used against you. And you'd have the right to be presumed innocent until the burden of proof was met by the prosecutor. Do you understand all of those rights that you have?
Yes.
All right, we're going to proceed then with a contested hearing. Mr. Fortier, call your first witness, please.
Your Honor, we would call Erica Walker.
Ms. Walker, can I have you raise your right hand so I can swear you in? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you very much. Could you state your full name and spell your last name for the record, please?
Yes, it's Erica Walker, Walker.
Thank you very much. Mr. Fortier, your witness.
Thank you, Your Honor. Ms. Walker, can you hear me okay?
Yes, sir.
All right. So I want to start off. Can you tell me where you're presently employed?
Yes, I work currently at Redwood Toxicology Laboratory, which is Abbott, which is located in Santa Rosa, California.
Okay. And what is it exactly that you do at Redwood Toxicology Laboratory?
I'm a forensic toxicologist. What I do, I review and interpret drug results for various agencies throughout the United States. I am considered the custodian of those results. I testify to those results. I also participate in testing from time to time. I provide letters of interpretation, litigation packets, peer review, ongoing studies, just to name a few.
Okay. And how long have you been employed with Redwood Toxicology Lab?
Since August of 2019.
Okay. Where did you work before Redwood Toxicology,
Prior
if
to
anywhere?
that, yes, prior to that, I have over 30 years of experience working in several forensic laboratories, two forensic laboratories as a forensic scientist in drug analysis and toxicology.
Okay. So what's your education background?
I have a bachelor's in biology with a minor in chemistry from Kentucky State University. I also have a master's of education specializing in community health.
All right. And when did you obtain those degrees?
And it's been in one, I think it's in 1993 and 1997.
All right. And after you obtained your bachelor's in biology, what did you do after that? Did you start working right away?
I did start working. I held several positions in the science field until I was hired first. My first position was at the Cleveland Police Laboratory in Cleveland, Ohio, as a forensic scientist.
Okay. And so have you since let's say around about 1995 or so, have you consistently worked within the field of forensic science and or toxicology?
Yes, sir.
Um, Now, when you work in that sort of field, is there any sort of continuing education requirements or training that you have to take part in?
Yes, I've taken numerous um, courses and also through different organizations, which I am also a member of. So it's continuous classes and studies in my career.
Okay. And Your Honor, at this time, I would move to have the court deem that Ms. Walker is an expert in the field of forensic science and forensic toxicology.
Mr. Brown, any objection?
If I could just have one question.
Certainly.
Ms. Walker, have you ever been qualified as an expert in a court before?
Yes, good morning. Yes, I have testified over 500 times in federal, state, and local court.
As an expert?
Yes, sir.
Thank you, ma'am.
No
No objection, Your
problem.
Honor.
All right. Ms. Walker will be qualified as an expert in forensic science and toxicology, and she may testify accordingly. Go ahead, Mr. Fortier.
All right. Ms. Walker, I want to talk to you a little bit about a drug test or a urine screen, at least, that was received by Redwood Toxicology. It's for a donor by the name of Dustin Proctor. Are you familiar with that
Yes,
specific?
yes, sir. I'm sorry.
So I want to, if you know, when did Redwood receive that specimen for testing?
I do have it on my person, if it's okay, Your Honor, I have it here.
Certainly.
Okay. Yes, it was received by our laboratory on July 28th of 2025.
All right. And what happens to specimens that are collected and sent to your laboratory once they arrive there?
Yes, upon receipt to the laboratory, an accessioning technician will review the specimen to make sure that the specimen is intact and all labels match. If there's anything wrong with the specimen, we would notate that on the report. If anything's also damaged or anything, we would contact the client to see if they still want us to move forward, if there's any specimen left. If not, we ask them to send us a new specimen. If everything's fine, then we will log everything in and it moves forward for testing.
Okay. And when Redwood received this particular specimen, was there anything noted that was wrong with it?
No, sir.
Okay. So was the specimen intact?
Yes, sir.
Okay. Was it received in like the typical shipping, I guess the shipping container, or whatever it's received in?
Yes, sir.
Okay. So nothing of significance noted to the actual specimen itself up front?
No, sir.
Okay. Nothing that would lead you to believe that any analysis on it would be compromised?
No, sir.
So now after Redwood is able to verify that the specimen is essentially intact and able to be examined, what are the steps that are taken from that point?
Once everything is logged into our laboratory management system, it goes forward for a pre-screen. A pre-screen is just a presumptive test that screens for classes of drugs. And if anything's detected or positive, if requested by the client, if they want confirmation, then it moves forward for confirmation. If not, it will stop there. If it's like negative or non-detected, or if the client doesn't want it to move forward for confirmation. But if requested, then it moves forward for confirmation. And the confirmation department, what it do, it rules out the classes and looks for a specific drug. And then
Okay.
after that, it a final laboratory report is drafted and it goes out to the client.
And do you know if this particular specimen for Dustin Proctor, if that was pre-screened?
Yes, sir.
And as a result of that pre-screening, was there classes of drugs that were identified?
It was a pre-screen, which is because it depends on the test ordered, because it compromised. They wanted a confirmation method, and within the confirmation method, it has the pre-screen. So it went through the pre-screen and confirmation method.
Okay. So explain to me a little bit about how the confirmation method works.
If you look on the right-hand side, it's a liquid chromatograph mass spectry. Mass spectry is considered. I'm sorry. So it's considered as the liquid chromatograph mass spectry, and it's considered our gold star, or per se the our platinum method, and it has a double mass spectrum on it that is highly selective and sensitive, that analyze the specimen and it rules out the classes and look for that specific drug.
Okay. And when this particular specimen was put through the those specific tests, was there anything about the instruments used that was not in working order?
No, sir.
Was there any issues with the test itself that caused any issues with those instruments?
No, sir.
So would it be safe to say that those instruments were functioning as they're designed to do?
Yes, sir.
And so I believe you said that once it goes through these specific instruments, it did you say it rules out classes of drugs?
That's correct.
Okay, so how does that process work where it rules out classes?
Example I can give is like example, I would say like cocaine, because it like lidocaine, benzocaine is in the cocaine family, and something might be like lidocaine to rule out if it's cocaine or benzocaine or anything, because it's part of that family, and it can be flagged in a pre-screen because it's under the cocaine family. So what happens when it goes through a confirmation method. It rules out the classes and looks specifically what that specimen contains.
Okay, so let's say, for example, a specimen is sent, would it be able to essentially tell the difference between amphetamine and methamphetamine?
Yes, sir. And also too, because if you look under the test method, it say amphetamines, methamphetamine is part of the amphetamines family, so it falls under that category.
Okay, but those instruments are able to tell the difference, though. Is that
Is
right?
exactly.
Okay, and for the specific specimen for Dustin Proctor, can you tell us what the results of that confirmatory testing were?
Yes, it was analyzed and found to be positive for methamphetamine.
All right. And was there anything about that test that indicates to you that it could be what some people consider a false positive?
No, sir.
Okay. Would that even be possible with these instruments to have a false positive?
False positives can take place in a pre-screen, but not the confirmation method.
Okay.
Confirmation rules out the false positives.
And can you briefly describe to me what the difference is between like a cutoff amount for testing versus the actual amount detected of a particular substance?
Yes, for cutoffs, cutoffs are basically levels that every laboratory have their own set cutoffs that they establish, and they're usually cutoffs are given according to their I would say accrediting and proficiency requirements. There's I would say method validation requirements. So each lab established that. So cutoffs or anything above the cutoff is considered positive or detected, and anything below that is considered as negative or non-detected.
Okay. And have you been trained on the different instruments that are used for the confirmatory testing?
Yes, I'm continuously throughout my whole career.
Okay. And I believe you kind of mentioned earlier that these particular instruments are considered, I think you said, the gold standard.
Yeah, some people say gold standard or platinum. Yes, sir.
Okay. So are these instruments something that is certified in the relevant toxicology community?
Yes, sir.
And is Redwood Toxicology Lab, is that lab certified in the relevant toxicology community?
Yes, sir.
Your Honor, I don't believe I have any further questions at this time, and I would tender the witness.
All right, thank you, Mr. Fortier. Mr. Brown, your witness.
Thank you, Your Honor. Ms. Walker,
Yes, sir.
when you receive these specimens, do you have any firsthand knowledge or knowledge of how these specimens were obtained or handled before you receive them?
No, sir.
You said that you received them, nothing wrong was noted or anything. What did you mean by that?
Yes, what happens sometimes, because some specimens can come in and it can be damaged through UPS or FedEx, and sometimes it may not be no specimen left or because of the damage, or it may be damaged and some specimen left, or a majority of the time it's nothing damaged wrong with the specimen. So if anything is wrong, what we do, we contact the client, let them know there is damage to the specimen, or to see if it's some specimen left, if they want us to still move forward with testing, or see if they can send us a new specimen.
Okay, so when you said everything looked intact or nothing wrong was noted, basically what you meant was the shipping process.
Yes, that's correct, from when we received it. Yes, sir.
So you don't have any knowledge of how the specimen was taken or who took it or the procedures or processes by which they employed. Would that be correct?
Yeah, prior to coming to the laboratory, I would not be able to speak on that, sir.
And how would you know, or do your machines or the equipment that you use, do they test for any kind of contaminants?
Yes, we do. We do calibrations throughout the day. If anything is wrong with the instrument, then it would automatically shut off. So we do have checkpoints in place to make sure that that don't happen. And also too, we do have outside bodies that come in to organizations for testing. They come in unannounced and come in and look at the instruments, are testing, look, observe the scientists that are testing. That's provided. So yeah.
And this particular test, did you perform this test
I
personally, or
No, I did not personally do this test.
about how many hands does this typically flow through this whole process from once you receive a specimen to the final result?
Actually, it could be three, up to three persons, or two to three persons.
And what is your main role in this then? Are you relying upon the results by those persons to interpret what their test results are?
What I do, I participate in testing from time to time, so I personally do provide testing also too. And then too, I am considered as the custodian of records, so as for our laboratory. So I do, if I have to go to court or anything like that, I do go back and review every step of the process if it wasn't myself that provided the testing. In this case, I did not provide the testing, so I have reviewed every step.
And those steps, I'm going to assume, do you review those by speaking with these people, or do you just look at maybe some steps that are noted in a logbook?
I do both, actually.
Now, you stated that in a pre-screening, it rules out certain classes of drugs. There may be some error there. But you said that once it gets to the final confirmation, is it, I mean, literally impossible to be wrong?
As far as with my career, I have never experienced anything like that too. I can't say anything is impossible, but as far as my career, I've been doing this for over 30 years in the confirmation method. I have not experienced anything as like a false positive being not a pre-screen, but a confirmation. Sorry about that.
No, that's fine. Is there anything else that was found or screened for? I'm clearly not as intelligent as you, but I do know that certain drugs have metabolites or maybe show other types of drugs as the things metabolize. Was there anything else there that you would normally associate with methamphetamine present?
You know what? With methamphetamine, it breaks down into amphetamine, and sometimes it all depends on everybody's system. Because, like, you might break it down into amphetamine, but if I take it, it might still just show methamphetamine. Because due to our bodies, and it could be simultaneously taking other drugs, medications, or health conditions. It differs from male, female, so it varies. So just to see if you don't see a metabolite in a specimen doesn't mean that it won't eventually, or it may not break down, because you may not break it down into amphetamine, whereas I may, if that makes sense.
So it depends on the person then, whether it even will break it down into a metabolite.
Yes, sir.
And is it odd for you, or I don't know if you know this or not, but the only thing that is showing on this test is a methamphetamine. Amphetamines are negative, everything else is negative. Is that odd?
No, no, sir.
And I don't know how to ask this, but I'll try to approach it.
Mm.
I believe it was gone over before that Mr. Proctor was testing about every day. He tested negative the day prior, negative the day after. How does that work as far as the drugs staying in someone's system?
You know what, too, a lot of things, like when you look on a report, you might see the creatinine. It is still, again, from person to person. Um, it can happen that way. A lot of times too, another factor can factor in, like if a person how hydrated, the time of testing, if they're got other taking other medications. It's a lot of factors that can come into play to and how fast they metabolize something. So that's possible that it could be a fast metabolizer, metabolize out of the system. And whereas it might take me a couple of days to metabolize. So it still varies.
Okay, I don't know based on your experience, if you've analyzed things that have been tested every single day, um, do you have any idea of perhaps an amount that might be present to test negative both the day before and the day after? Could it have been a residue amount or something like that?
You know what, too? I wouldn't be able to tell the amount ingested still because there's those other factors that come into play. So I wouldn't be able to speak on that. And for us at our laboratory, they try to steer us to stay away from amounts because they look at anything above the cutoff as still considered as positive or detected, and anything below that considered as non-detected or negative. And sometimes some people might come up negative and it might just fall just below the cutoff. And it doesn't mean that they hadn't taken it, but it just fall below our cutoff or another lab's cutoff.
Well, I'm looking, what is the creatine? I'm
Creatinine.
creatinine, yes,
Yes,
yes.
it's a byproduct of muscle metabolism that's really consistent over a 24-hour period. Anything above the creatinine at 20 nanograms per deciliter is considered as normal, and anything below that is considered as like dilute.
Okay, so this looks like it's normal. This wasn't a dilution, correct?
That's correct.
And did you happen to quantify the level that was detected? Or is it just it was over the cutoff?
For the creatinine, or are you talking about the
For the methamphetamine, I'm sorry.
okay, can you rephrase that question? I'm sorry.
Did you quantify the amount or the level, or is it just a positive or a negative based on the cutoff?
No, if you look at the report right next to it, it says 644 nanograms per milliliter. So it is above our cutoff, which is at 250 nanograms per milliliter.
And again, as far as a cutoff amount, you wouldn't know if that's a speck of dust or if it is a gram. Can you make that association or no?
No, I wouldn't be able to make that association.
Essentially, these machines work on molecular levels, correct?
That's correct.
So if it detects this cutoff at a molecular level, it's going to show positive without regard really to how much or any amount.
It would show above our cutoff level at 250 nanograms per milliliter. Anything below that, it would show it can be present, but it may not show because that's our established cutoff. So it can be negative or non-detected. We just didn't detect it because it wasn't above the cutoff.
I just have one last question for you, and you might not be able to answer this because I'm trying to figure out what a nanogram per milliliter is.
Very
Could you
small.
explain that in my kind of terms, not knowing any of this? Like is that a drop of ink?
It's hard to say. It could be like a drop of ink in a gallon of water or something. It's very small.
Okay. All right. Thank you very much.
No
I have no further
problem.
questions, Sean.
Mr. Fortier, any follow-up?
No, Your Honor.
All right, Ms. Walker, let me just ask relatively straightforward. The defense counsel asked about a negative test the day before and a negative test the day after, and you said I think I understood you say it wouldn't necessarily invalidate the positive test that you are testifying about today. Is that correct?
Yes, Your Honor.
All right. And defense counsel was trying to get a sense of how big an amount the 644 nanograms per milliliter was. Would it be safe to say that that's more than double the cutoff level at 250? So whatever that amount is, it's more than double, well on its way to being almost triple the size of the cutoff. Would that be accurate?
Yes, accurate. Yes, Your Honor.
All right. I don't think I have any other questions. Do either counsel have any questions based on mine?
No, Your Honor.
No, Your Honor.
All right, Ms. Walker, thank you very much for your testimony. You're free to go and you're released from your subpoena at this time. Thank you very much.
Thank you, Your Honor. Thank you, everyone.
Thank you.
You're welcome, ma'am.
Bye-bye.
Mr. Fortier, do you have an additional witness?
Your Honor, I think what we can do is I'm just going to ask the court to take judicial notice of the court file, which should contain the drug court bond conditions.
I can certainly do that.
And with that, I would have no other witnesses.
Mr. Brown, any witnesses or evidence?
No, Your Honor.
Arguments then as to this matter, Mr. Fortier.
So, Judge, with the court having taken judicial notice of the court file, the bond conditions would note signed on May 15th that bear the defendant's signature were signed and ordered by the court bearing Your Honor's signature on the same date. I would point to condition number 3 is you are not to purchase, possess, or consume any alcohol, marijuana, or non-prescribed controlled substances. We have the positive test for the methamphetamine was testified to by Ms. Walker that it's at that 644 nanograms per milliliter. So well above the cutoff of the 250 nanograms per milliliter. I think it's significant to note that she did indicate that although false positives are possible at the pre-screen level, the instruments used in the liquid chromatography and mass spectrometry, it's not something that's possible. So we don't have a false positive. We have a confirmed positive test for methamphetamine obtained by Mr. Proctor it was collected on 7/24/2025 at 7:48 a.m. by Mary Payne. It was submitted to Redwood Toxicology Labs and received. There was no indications that the specimen was not intact. It went through the whole process. It was received on July 28th, 2025, and the report was generated on July 30th, 2025. I think we've met our burden of preponderance by the evidence to show that this was a bond violation, that he consumed methamphetamine on or about sometime prior to 7:48 a.m. on July 24th, 2025, which is after the date that he signed the bond conditions acknowledging that he is not to possess or consume any non-prescribed controlled substances. As far as we've been made aware, he does not have a prescription for methamphetamine, so there's no reason he should have it. It is confirmed methamphetamine and not a mixture of something, say, for example, amphetamine and methamphetamine. It was confirmed methamphetamine. It ruled out any amphetamine confirmation. I think I do want to kind of touch base on a note that it's kind of brought up by Mr. Brown during his cross-exam, kind of see where it was going. I did want to point the court to the Michigan Rules of Evidence, just pointing to Rule 1101, subsection B, subsection 3, which indicates that rules with respect to hearsay do not apply in proceedings with respect to release on bail or otherwise, which is exactly what we have here. This is a bond violation hearing, so it's a the hearsay issue that there might be about this report being generated based on someone else's testing under general circumstances would probably be considered hearsay in a trial, for example. But with respect to the bond violation hearing, it's not, so the court can rely on Ms. Walker's testimony. And I believe we've proved, again, by preponderance of the evidence that this was a positive sample for methamphetamine, and I would ask the court to revoke Mr. Proctor's bond based on that positive screen.
Mr. Brown.
Your Honor, the only argument that I believe that I can reasonably make here, because this is a very, very low burden, is that there are numerous factors and variables that would go into this. While it is possible that it could be negative one day before and after and still test positive that one day, it is also not without the realm there that it didn't, if something else was going on. If Mr. Proctor was going to do something like this, knowing that he was testing the day before and the day after, usually if you're going to have a relapse, it's going to be a relapse. It's going to be a go big or go home kind of a thing. I think that it would have had to have been such a minute amount. And again, I know she probably couldn't put an exact amount on it, but it is a very, very small amount. It could have potentially been residue. It could have been by accident. It could have been ingested or something like that without him even knowing it, depending on where he was at or who he was with. We know that he does have, the court knows what his criminal history is here. So there may be that possibility as well. But again, I know this is a very low burden. I would ask the court to take all of that into consideration, just that there is that possibility, whether the court believes so or not beyond a preponderance, that he did not purposefully do this. Otherwise, he probably would have tested at much, much higher levels, and that would have been very, very obvious. But that this is a potential just an error or mistake that was unknowingly ingested this substance, Your Honor. Thank you.
All right, thank you both very much. As both counsel have noted, the burden of proof in the bond violation hearing is preponderance of the evidence, which is a 51% more probable than not standard. It is the same standard that would be used for a informal or formal traffic citation. Which side has produced the more believable evidence? In this case, the prosecution has shown through reputable testing and expert testimony that Mr. Proctor submitted a sample that was returned with a result of 644 nanograms per milliliter, indicating methamphetamine on July the 24th. The court can take judicial notice of the bond violations which were entered in May 15th, which required that Mr. Proctor not purchase, possess, or consume any alcohol, marijuana, or non-prescribed controlled substances. It's very clear that he had within his system on July the 24th in his urine sample that was tested methamphetamine. The testimony from the expert was that the instruments were working correctly, the testing process was run properly, that the lab is accredited, that there's random observation. So there's no, in the court's mind, there's no indication that there was any faulty lab work or faulty lab testing. The expert also testified that there's been no false positives in the confirmation of the testing, maybe in the pre-screening, but not in the confirmation with the mass spectrometer. In her 30 years of experience, she explained numerous factors which could explain a negative test result before and after the test in the days preceding and succeeding, including the amount ingested, the metabolism, and the hydration of the individual. I understand defense counsel's argument as to what other factors might explain those things, but that sounds, and quite frankly, is speculation on defense counsel's part at this point. There was no proof adduced as to whether or not there was any actual facts supporting that argument. He was simply making a logical argument. However, there's no facts supporting that, so the court's not going to draw any conclusions from that. I do find that the testing was proper, was accurate. And I do find that on July 24th of 2025, Mr. Proctor had within his system methamphetamine, which would be a bond violation, as noted previously, and I will revoke his bond as a result of that. And it will also be considered as part of the sentencing process, which we're going to move to now. Mr. Fortier or Mr. Brown, is there any reason why we should not proceed immediately to sentencing in this matter?
So, Judge, I guess my only question would be, based on this particular bond violation, plus the sanction report that was filed by Mr. Hanlon earlier today, plus my personal observation of seeing Mr. Proctor drive a vehicle without a license, is he still being admitted into the drug court program? And if he's not, does sentencing still take place in front of your honor? Or does it have to be sent back to be assigned to either Judge Hunter or Judge Mertz? And in any respect, do we have to have an updated PSI based on the bond violation occurring prior to sentencing?
Mr. Brown, your thoughts?
I would agree with that, Your Honor. I'm not sure if it needs to be sent back up to a different judge. I'm not quite sure how that works. But I do think, looking to see when this PSI was done, I do think we would need an updated PSI.
Yeah, it was done, at least my copy was printed on July the 8th, which was obviously before today, and so it would not contain the bond violation decision. And I think it might be prudent to get circuit court, well, depending on what I decide on the whether or not he's going to stay in drug court or not. So I guess I'll say it this way, just to let parties know so they can conform their arguments around that. I will hear arguments on whether or not Mr. Proctor is to remain in drug court. If I decide he's not going to remain in drug court, then I'll remand it to circuit court for an updated PSI. And even then, I may remand it for, well, I don't know that I need to update it unless there's some argument that I need to, but I think I want to make a decision today about whether or not he's going to remain in drug court. And then we can argue about whether or not it should be remanded for an updated PSI and sentencing by a different judge. With that limitation, then I'll hear arguments from Mr. Fortier as to whether or not Mr. Proctor should remain in drug court. And then I'll hear from Mr. Brown. Hang on just a second. So Mr. Fortier, as to the sole issue of whether or not Mr. Proctor should remain in drug court, any arguments?
So, Your Honor, I don't believe he should remain in drug court, and the reasons why are kind of as a whole. I think it would be unwise of me to not acknowledge that, I mean, as part of the drug court program, we expect to see relapses. It's not something out of the ordinary. I mean, when you're talking about individuals who enter our program, of course, they're going to have substance abuse issues. That's the number one criteria for them to even get admitted in the first place. So, I mean, positive tests are not in and of themselves necessarily to the point where they're offensive enough to say, I don't want this person in the program anymore, because we expect relapses. It's in the memorandum of understanding that we all look at. However, this one is a little different, I think, given the fact that since he has acknowledged his bond conditions on May the 15th, there's been a repeated course of conduct where he's just not following the rules. He's not following his bond. Obviously, the court just revoked his bond, so that issue will have to be addressed. But I mean, on May 16th, testing positive for alcohol, where the court heard the sanction. And if it recalls, defendant tried to really downplay it and even kind of lie. I will go as far as saying is lie to the court about the circumstances. The court sentenced him to jail. There was the driving on a suspended license case that was filed on May 20th that was pled to a few weeks ago. Do those in and of themselves necessitate he doesn't stay in the program? I don't think so. But when you couple those things together on top of a no call for a scheduled drug screen on June 6th, a no show for a drug screen on June 18th, a positive test for methamphetamine on July 24th, a no call for a scheduled drug screen on September 4th, on top of the fact that I've personally seen him driving a vehicle knowing that he has a revoked license. And I believe the court has the pictures that were obtained today showing him leave the courthouse driving a vehicle that he is currently sitting in the driver's seat of while he's here on Zoom with us. He's not being honest with the court. He's not being honest with the probation department. He's not being honest with himself. And I think though all of these events coupled together show that he's just on bond conditions, he's not even taking the program seriously. So what are we going to expect if he stays in the program and he keeps doing these things, and the participants week in and week out are going to have to see this individual's out there continuously no call, no showing, testing positive for substances multiple times, just is out willy-nilly doing what he wants, driving a vehicle. So I just don't think that he should be given the benefit of the drug court program for a second time. He was out of it for just, I want to say around about a year before he came back to us. So I don't think that the court should give him a second bite at the apple, because his conduct has kind of shown us that he's not taking it seriously.
Mr. Brown.
Hi, Your Honor. Firstly, I was unaware of the allegation that he was driving again on a suspended license until just right before court. So I really didn't have an opportunity to address that with Mr. Proctor. The court has already made its finding on the bond violation. In speaking with Mr. Proctor, he really does want this. He does not want to go back into a jail or a prison where he may be clean for a period of time and get absolutely no education on how to help himself and how to maintain sobriety, or maybe even deal with certain other aspects in his life. The driving on a suspended license, while it may seem like no big deal when we're talking about methamphetamines or drugs, it is a bond condition and needs to be taken very seriously. And I don't know if it is simply a matter of necessity, which oftentimes it is, when we can't find rides or we can't get public transportation. And unfortunately, we either get held in contempt of court, we lose our jobs, or sometimes people need to get transported to where they're going and take that chance. I don't think he is doing it to necessarily flaunt the court, or like, I really don't care. He is taking this very seriously, testing whenever he can. There have been some times he may have called at 7 o'clock, or not 7, but maybe 7:15 or 7:05 or a little bit after 7, and then still goes in and tests that day. So I do know that he wants this. And I don't know if he wants if he wants to say anything on his behalf, but if he does, I would caution him to kind of watch what he says. Thank you, Judge.
Mr. Proctor, I will give you an opportunity to address me if you wish. I'm going to concur with Mr. Brown and say, please be careful with what you say. I don't want it to be used against you in any way in any future court proceedings. But if there's something that's specific to this court proceeding and whether or not you should stay in drug court, I'd be happy to listen to that, sir. This is your opportunity.
Yes, Honor. I want to mention that, as my attorney said, I do want this program. I have messed up. Yes, I am trying to show you, I'm trying to show the team, I'm trying to show Mr. Fortier that I want this. But all the time I'm learning ways to be sober myself. Last time I was in the program, I got sober for all the wrong reasons. And I can admit that. This time, I want to be sober for me. I want to learn how to stay sober after the program. I want to take all the tools I can with me to pass it on to people and tell people there is a better life than using. I want to continue to try to be sober and stay sober. I'm everything I'm doing out here is to show you that I want to be there, and that's, you know, the chairing of the meetings, changing the meetings from Mondays and Wednesdays to Tuesdays and Thursdays so I can chair them. Going to church, I'm doing, if I don't make it in person to a meeting, I'm doing online meetings every day. And then the in-persons when I can, which is every Tuesday and Thursday and sometimes Sundays. I'm working my job. I'm doing everything I can. On Mondays, every other Mondays, I volunteer over the food pantry when they have their truck days. Like this Monday, I'll be going over there. So I'm trying to prove to you guys that I want to be in the program, and I do want to be in the program. I want to be in the program because it's there to guide you through sobriety and how to achieve sobriety for the long run. And I never took that out of the last time. I never tried. I want to try it, and I am trying. I want to be here with you and the team for this program.
Thank you, Mr. Proctor.
Thank you, sir.
Mr. Proctor, you present to me as a conundrum wrapped in an enigma.
Can
It's
you explain
difficult. Yes, I'm going to. I'd be happy to. It's a famous quote from Winston Churchill. I think I probably messed it up, but the idea behind it is you're a very difficult circumstance to understand. You present to me today saying all of the right things. I want to be in the program. I want to change. I didn't change last time, and I recognize now that I need to change. But every time I have brought you into court with an allegation against you and it's been proven, you then back up and say, well, you're right, you got me, and now I want to change. But you won't tell me those things ahead of time. You don't admit, at least you haven't in the two cases that I've had so far on the bond violations or the drug court rule violations. The alcohol issue, you didn't admit. And then as soon as we found you guilty, you did say, and then you came into court the next time and you said, well, I've got an idea for an alcohol business that I want to open. So you say the right things.
I'm sorry, Judge.
You're done. You're done
Okay.
at this point. This is my thought process.
My apologies.
You wanted to come into court and you apparently didn't realize that operating a mixology, alcohol mixology business is the same problem that you've always had. It's another substance abuse issue. And you just don't seem to get it. And I don't know whether that is truthful inability to understand or whether you're just trying to con me continually. That's why I say that you're an enigma. It's something that nobody really understands. It's a thing, but nobody understands what it is and why it is. So here's the problem I have. Do I bring you for lack of a better term, a hurricane that makes a lot of mess and throws a lot of stuff around into the group? And my decision on that is no. I would love to have you get treatment, but if we bring you into this group, or if we keep you in this group, your hurricane, your massive confusion and misunderstanding and whatever else that you've got going on is going to negatively impact the rest of the group to the point where it's going to cause somebody else to fall off the wagon. And I simply can't have that. I wish there were an individual group or an individual counselor, and I hope that there is somebody like that out there for you. But you've already had one bite at the apple. You've already been in this group. You've already had the opportunity to go through it, use the tools, get the understanding, practice those skills, and it hasn't had sufficient effect on you to bring you into compliance with the rules, even to be entered again this second time. So I'm not making a finding on whether or not you were driving with your license suspended. I'm not making a finding that whether or not Mr. Fortier saw you today or not driving, or whether Ms. Payne saw you today or driving. Quite frankly, this is a bond hearing. I can use hearsay. I could probably make such a finding, but it really doesn't make any difference. The fact that you've been found twice now, after adjudications, found twice now to have violated the policies of the drug court, but once with alcohol back in May, in which you were sentenced to jail, and then today where you had your bond revoked, that is sufficient for me to say that you're not going to be in drug court. I simply can't have you. I think you need it. I absolutely understand, and I believe that you need it. And I would hope that you would seek out other areas that could give you those skills and where you could practice those things. Because I sincerely, I think, I'm going to take the high road here, and I think that you want it, but you've got so much weight on your back from all of the bad decisions that you make otherwise, you can't see yourself straight right now. And I can't have that much mess and problem in the drug court with everybody else. You're just too big of an issue right now for this drug court to take on along with everybody else. I wish that wasn't so, but it is. So I'm not going to let you in. What I am going to do is I'm going to remand this matter to the circuit court because without the drug court consideration, I don't think it would be appropriate for me to impose the sentence. If the circuit court judges feel otherwise, I'm happy to have it remanded back to me, but I'm going to say without the drug court consideration, I don't think it's proper for me to do it, as I am normally just a district court judge and my jurisdiction is only over the drug court and he's not going to be in it anymore. So I'm going to remand the matter for circuit court sentencing and for an updated PSI, given the bond revocation. Mr. Proctor, you have to go directly to the Otsego County Sheriff's Department and turn yourself in. Your bond has been revoked. If you don't do that, a bench warrant will be issued for your arrest and you will be picked up as soon as the police find you. And it's highly unlikely that you're ever going to get any other kind of bond if that happens. So you are remanded to the custody of the sheriff immediately. Go directly to the Sheriff's Department and turn yourself in. The paperwork will join you there shortly. Mr. Brown, do you have any questions about anything?
No, Your Honor, thank you.
Mr. Fortier, is there anything else?
Judges, is there going to be a new bond amount or is he going to be held pending sentencing with the circuit court? Which I guess my preference would be that he be held pending sentencing with circuit court.
I don't think he's been a flight risk, Your Honor, so I would argue against that.
Well, he was in Ohio as short as 6 or 8 months ago and was living down there as long as I'm aware of, as far as I'm aware of. I'm going to say $5,000 or $10,000 cash or surety. The bond right now is 5,000 PR. That's been revoked. $10,000 cash or surety. And then if he doesn't show up, then there'll be enough for us to go get him on. All right. That's all for today. Thank you.
Thank you.
Good luck to you, Mr. Proctor.
Thank you.